legislation was an issue. 14C was the download from, I think it was the BlackBerry, was it? Yes, it's from the BlackBerry. So 14C was a separate. It was effectively a separate issue.
So we're not dealing with.
We're not dealing. No, exactly.
Dealing simply with JS2. And just in outline summary, what did that include? They were the conversations, as I understand it, between. Sorry.
No. Sorry, that was rude of me. Sorry.
Well, I was going to say the conversations between the deceased and his girlfriend. Is that right? While travelling, allegedly.
Yeah, you're right.
Yes.
Yeah, and then does it also include Mr. Wee? Evidence in relation to what he.
You mean Mr.
Chow?
Sorry, yes. There is evidence. There was communication in relation to Mr. Chow.
Well,
the best, possibly
results
the best
that come
summary,
out after them. So we just have to
I mean, obviously, in one sense, one of the reasons for not focusing on what it concerns is that, in relation to the jury issues, the Crown's case is the matter was
just some next one,
in light of JS2, which demonstrates in one sense its significance. The summary, though, of what it included is para 155 of the Court of Appeal's judgment.
Thank you.
Page, sorry, yes, 5837.
Thank you.
Daniel,
it's also just worth noting paragraph 24 of the Court of Appeal's judgment, which notes how that also summarises the evidence and notes in particular, it goes to the point my Lord just raised about Mr. Chow, and that's 5783, paragraph 24, and that's relevant because it notes that this material was relied on to show constant communication between the defendants and Mr. Chow.
Do the ladder.
It also was then the basis, there was a certain amount of cell site analysis, and it was the basis of that. And you see that in the trial judge's summing up at 5071.
Drop some likes on the stream, guys. Come on. I haven't been live for a long time.
Not paragraph 13, line 13. And just to put it in context, one of the reasons why it was also relevant was this was a case where the live evidence, essentially, in relation to Mr. Chow, had real question marks against it. And that's, in one sense, demonstrated by the acquittal of Mr. Williams, who was a defendant the Crown's case entirely consisted of Mr. Chow in that case. So where Mr. Chow was the sole evidence, there was an acquittal, essentially.
So, just so I'm absolutely clear, so the evidence in relation to what Mr. Palmer had on his BlackBerry is not part of what we're now concerned with?
No.
What about the video in relation to Mr. Chow?
Can I just double check on that with my team? But I don't think that's within the material. I don't think that's within JS.
That was in 14C, as I understand
it. That's right. Yes.
So 14C is completely out.
Yes.
Yes. Thank you very much,
Mr. Southey. Paragraph 155 of the Court of Appeal doesn't so much summarise the contents of JS2 as the use to which it was put. JS2 was put by Corporal Brown.
Well, yes,
no, in the last word, in stammer like me, we have a speech impediment,
in one sense, how important JS2, because JS2 was raw data, which was then presented by Corporal Brown through effectively his own interpretation of it. So that's why the summary is there, because he was effectively presenting the evidence.
Where do we find a summary of the content?
I'm not sure there's a... Sorry.
No, I think it's fair to say one doesn't. My Lord's actually done a trail to find out exactly what was on JS2, and I've recently seen
where can I watch this?
JS2, which entirely fits the summing up. But I can tell you what it
JCPC Live. Type in JCPC Live.
It would be helpful for us to know what it contains.
Yes.
And perhaps, Mr. Southey, if I say what I believe it contains, Mr. Southey can then take instructions. My Lords, what JS2 was the disk, as I understand it, and then from that disk, Corporal Brown drew up a spreadsheet, various spreadsheets. Now, the first spreadsheet consisted of texts. Second was a spreadsheet of phone calls. And it was drawn up, these spreadsheets were drawn up from 4 telephone numbers. That is to say, Mr. Chow's phone number, the deceased's phone number, Mr. Palmer's phone number, and Mr. Campbell's phone number. So they were the only phone numbers which were the subject of JS2, A, in relation to texts, B, in relation to calls. Now, as far as the texts were concerned, what they consisted of was the following. Text between the deceased and his girlfriend.
Drop some lights on the stream, please.
On the 14th and 16th of August 2011.
16th
of August 2011, that being the date of the killing, we say. Those texts are summarised in the summing up at E4788 to E4791, and we also summarise them in our case at 27 hours 40 and 41. But essentially, they're the ones where the deceased is saying, I'm getting more worried. The second set of texts are to and from Palmer between the 8th and the 12th of August 2011. But they appear to be of no importance at all. They don't appear to be referred to in the summing up. They were read out to the jury, but they don't add anything. The third set of texts were those from and to Sean Campbell, which are, to an extent, incriminating, and they are referred to in the summing up. They suggest that on the day of the killing, but before the killing, Campbell knew that the deceased was going to be executed. He had to die. And they suggest that after the killing, he knew the killing had taken place and they needed to get away. And you can see a summary of those texts.
Shani, I saw quotes there, man. I have to go by the book.
In summing up, at 4989 to 4991. That's where they're set out and explained. And importantly, my lords, it is a point you may have wondered, what about the other defendants? Now, it does seem as if texts were collected from the other defendants' phones, but they, after the voir dire, were excluded. And that, therefore, means there are no texts passing from St. John, passing to and from St. John, or Jones, or Shane Williams. They were originally in the original exhibit before it got to the jury, but by the time it got to the jury, those texts were all gone. As far as the call of telephone logs is concerned, that ran from the 10th to the 17th of August 2021, and what they did was indicate the nearest cell site which picked up the respective calls. And they did show, again, when Palmer was receiving or making a call, likewise Campbell, likewise the deceased, and likewise Chow.
Stefan, are we confused?
I should say, and Chow. There don't appear to have been, as far as I can make out, any texts from Chow. So that's the nature of JS2. But the only really incriminating material in JS2, as such, are the text messages passing to and from Campbell shortly before and shortly after the killing. I say incriminating, of course, those between the girlfriend and the deceased were incriminating, but they are not from Campbell, they're from the deceased's phone. I think I've given you the references where you can find it all in the summing up. We don't summarise all of it in the case, but we do summarise quite a bit of it in our case. We have tried to get hold of, I think it was Exhibit 10. There are some difficulties getting hold of Exhibit 10, that's all I can say. I have seen what we believe to be Exhibit 10 in relation to the texts. I was handed another exhibit, which plainly was the unedited version in relation to telephone calls. So we haven't put that in. But we can make available what I believe to be the exhibit in relation to text messaging.
And did the judge sum up in relation to the cell site evidence?
No, not really, apart from what you've just shown. I think it's fair to say not much appears to turn on the cell site evidence. I will address you later as to why I say very little turn on it.
Thank you.
Can I say, from the appellant's point of view, one of the reasons for,
not yet,
in one sense, perhaps not drilling down into the details of JS2 was for two reasons. Firstly, the clear position of the Crown, as I say, which is to rely on JS2 as being part of the reason why they argue that the proviso should be applied in relation to the jury. That, we would submit, is a clear indication of the potential importance of JS2. The other is that, as I've already indicated, the clear indication is that this was a case where, in particular, the only direct witness, Mr. Chow, was someone who appears to have been regarded as unreliable by the jury on the basis of, given the acquittal I've already drawn attention to. And that demonstrates the potential importance of the technological evidence. Can I go back, though, to the point that the reason I was talking about what was being argued below and drawing attention to the fact that there was no debate about the, it's clear, it was accepted that there was an argument that JS2 should be not admitted in light of the Charter, and in particular the breach of the Charter. The reason I draw attention to that is because effectively what the Crown does is argue that what is now being put before this court is a new point. That's a part of the Crown's response. In summary, we don't accept that is right for these reasons. Firstly, as I've already indicated, it is clear that the issue of a breach of the Charter was before the trial judge. That's accepted. Now, the arguments may be different, more nuanced, may rely on authority.
Yeah, it's live now. Yeah, them live.
But that doesn't mean that the issue wasn't before the trial judge. Linked to that, clearly the Court of Appeal's question that relates to this matter is premised on there having been a breach of the Charter. All the way through.
4:30 England now, 4:27 England now.
References in a moment. All the way through, from trial court up to Court of Appeal, the way in which this matter has been dealt with is on the basis that it appears to be accepted that there is an issue in relation to the Charter, and the question was, what implications should that have? And that's why the Court of Appeal then, we would say properly, referred a question about the approach that should be adopted by trial courts to evidence that's obtained in breach of the Charter. And so we don't accept that this is a case where we're prohibited in some way from arguing what we're arguing. We're arguing the same argument, the same issue that was raised at both courts below, albeit perhaps slightly more nuanced.
Drop us up on the chat, guys. Drop us up on the channel, please.
Now, in terms of the nature of the breach, because our case accepts that there is no automatic rule that a breach of the Charter will inevitably lead to exclusion of evidence. It is a more nuanced argument than that. It's important in one sense to be aware of the nature of the breach. And in one sense, the starting point in our submission in relation to that has to be the legislation, the section 16.
Look, bro, hold on.
Section 16 of the Interception of Communications Act, which is at 6277, the relevant passage, Section 16, the Act, and that is Section 16.2, and it is not a complex piece of legislation, which is probably a virtue. It requires a designated person to make a request.
Yes, live. Yes, Goddess.
And it requires an authorised officer to receive the material. Designated person is defined. Section 16, page 6276, the preceding
They want this part already unrolling?
Person
all right, what
someone
then?
who's prescribed by
you
the
can
minister.
Tell what happened then, Doc.
Section 2 defines what is an authorised person, authorised officer, and that's at 6257. It's a number of specified officers within law enforcement. Two other features of this legislation that are worth noting.
Hey,
Firstly,
if
if you go to 6279, Section 17 links compliance with Section 16 to admissibility of evidence. And Section 4 demonstrates in one sense that what this Act is about, consistent with the terms that of the legislation that I've taken you to already, because Section 4 is concerned with warrants, essentially, for interceptions. And what that demonstrates in my submission is what this Act is about prescribing safeguards in circumstances where what the Jamaican state is, and what Jamaican law enforcement in particular is seeking to do, is interfere significantly with the rights of individuals to privacy. So it is a piece of legislation that's intended to put safeguards in place and clearly requiring officers of sufficient seniority, essentially, to authorise gathering of data. It is an important part of seeking protection, of protecting the rights of privacy. Now, in this case, Corporal Brown was the officer who made the request, as I'm sure you've picked up. He said expressly that he was at page 1631 of the bundle, line 19. He said expressly that he was familiar with the Act, and that was hardly surprising because his whole role, as he gave, which he, according to him, when he gave evidence, was essentially to make requests under this Act. And you see that at 1574.
Probably retrial, Kirk.
Line 5, on line 5 to 13. Now, there's been an issue about what he was cross-examined about, and that's raised by the Crown in their case. He was cross-examined about his knowledge and a compliance with Section 16. If you go to 1632 in the bundle, he expressly said that from line 24 on until line 4, the following page, that he knew that there needed to be compliance with Section 16, and he believed that the notice that had been sent to Digicel complied with that. Now, that is, in one sense, a slightly surprising answer, given what he says almost immediately afterwards, because he was then cross-examined about the need for a designated person. And if you go to 1635 from the top of the page, he recognises that section 16 requires a designated person. He recognises that he wasn't designated. He says that twice, in fact. I'll just give you the reference. He also says it at page 1641. And so on the face of it...
He's not designated, but he is authorised to receive.
He claims he's authorised to receive. I think it's the Court of Appeal found he wasn't authorised to receive, but he.
The judge accepted he was in the voir dire.
Well, I'm not sure the judge actually expressly ruled on that, but certainly the Court of Appeal was of the opinion by the time that they'd got no evidence that he was an authorised person.
Well, did they get other evidence other than that was produced in the voir dire before the judge, where this matter was fully explored?
Well, the problem is, if you look at the evidence, there's his assertion that he's an authorised person, but he clearly doesn't come within the terms of the legislation, and there's no evidence there was no evidence that I can find that indicates how he gets authority when the terms of the legislation are clear. Similarly, that's why I assume the Court of Appeal said what it said, because on the face of it, it's difficult. Although that was his answer, he clearly doesn't come within the definition, and there's no evidence to explain how authority was in fact given. So that's why I think the Court of Appeal, I don't know, slightly speculating there, but that would be a good reason for the Court of Appeal to say what it said. But it may not matter, because in one sense, there was non-compliance. There clearly was nobody disputes there was non-compliance, and that may matter to some. I suppose the way which it may matter is it may go to how serious the breach was.
I'm telling about England. England not got discriminating because he have a stammer, brother. Remember, say England in there, bro.
Corporal Brown is
all person have the right to work if they want to work. So stammer or no stammer, them have to listen to him.
Just take you to it. Corporal Brown is saying, I know about section 16. I know you need a designated officer. I know I'm not a designated officer, effectively. So on the face of it,
am I doing job though?
That's a problem. Now, what he does suggest is, if you go to 1643, and this is all just to make clear in the course of cross-examination, which is clearly intended, we would submit, to determine why this breach occurs, and at 1643, 2022. Line 22, not 2022. Corporal Brown indicates that there may have been, that others may have been designated.
He names it.
He names them, yes.
922.
Yes. He names two officers, ASP Pascoe and Inspector Williams, as potentially others who may have been designated. But he accepted, if you go on to 1646, that he did not know whether or not they'd had the benefit of an affirmative resolution. And you will remember that the terms of the legislation are clear, that you need an affirmative resolution.
Brother. Even if a person have one arm and they want to work, you can't discriminate.
And he accepted that
if them go for the interview, once them qualify, you have to give them the job CMA, if them do a good interview, CMA.
He accepts at 1652 that he knew the request was not from a minister. And so you have on the face of it Corporal Brown saying, I know what the legal obligations
all right, Jay,
were.
if you watch it already, lift up and go on. Someone got to do something else with the time now.
I've assumed compliance.
We're not watching it yet. We're watching it now.
That reference to assumption, that's his language, not mine, essentially, at 1653, lines 13 and 14. And that, in our submission, suggests that this isn't, that there is at least a degree of negligence, essentially, here, in the sense that this is someone who understands it's his job. He understands that he is subject to legal obligations. He doesn't check effectively compliance with those legal obligations.
Doesn't he at some point say that advice had been taken?
That's, I think, if I remember rightly, there is a reference to that. I think that may be the Digicel witness from memory. I'd have to double check that, because but I think it was there was reference to advice, but I think that was the Digicel witness.
Perhaps we can come back to that.
Yes, but my learned junior has confirmed my memory is.
Thank you very much.
I'm always just a little cautious about saying things on my feet, but I think that's right. Yeah. It was the Digicel witness. And of course, the other factor here, which is something the Court of Appeal highlights, is that the Court of Appeal had already, by this stage, by the stage of the investigation, not the stage of the trial, but by the stage of the investigation, made clear that there was that what the terms
Thank
of
you,
the
Lynette. Thank you very much.
ICA were, the legislation were, in a judgment called Phipps. And the Court of Appeal point this out at 137. So it wasn't as though, I mean, the problem with taking advice was that that might have explained an initial failure to comply. But if you look at 137, which is 5828, they highlight the fact that Phipps demonstrated a flawed approach similar to that adopted by Corporal Brown. And that raises the question of, in one sense, even if Corporal Brown is effectively the relatively low-ranking officer who perhaps hasn't picked up the latest Court of Appeal judgment.
Yo, someone really done to them, brother. When you hear the man a stammer, and I first now hear somebody a stammer.
And that's one of the things that the Irish
that's all I worry about. Before I listen to the man I said, that's all I worry about. Someone done some fuck
for
that.
Compliance with constitutional
Stupid, bro.
rights.
Dumb.
It's not simply the person who's on the ground that you need to worry about. It's
number one, the man I work at
higher up
Jamaica,
the
the man
chain,
at Jamaica, dog.
and
England, the
why
man there, bro.
essentially was operating the way it
A person
was.
stammer in England, that's
This was a
nothing.
situation
Me
where the
stammer.
Jamaican police had been
England, me
told
live.
in Phipps,
That's nothing.
your process is
Doesn't
wrong.
stop me from getting a job, bro. Someone just dumb, dog. Like, stupid as fuck, bro.
And yet,
Thank you,
there's
Lynette.
no evidence essentially explaining how you then had Corporal Brown making the same mistake or a very similar mistake.
No, fire them, bro. Them dumb, bro. Them just not dumb
Now,
on dark
the
place.
Crown argue that it wasn't put effectively that the police or indeed Digicel acted negligently. A few things about that. Firstly, it was the Court of Appeal themselves who essentially pointed out the non-compliance with Phipps and the issues that arose in relation to that. Secondly, but perhaps more importantly, the word negligent wasn't used in cross-examination. I accept that. I can't find any reference to that. But the questioning clearly focused on the actions, whether effectively the actions of the police demonstrated that they were disregarding their legal obligations. What the questioning was focused on was how Corporal Brown had been in this position when the provisions were clear. Thirdly, in any event, I'm going to come on to make the point, based on case law, particularly Mohammed, that the burden was essentially on the prosecution to show to explain essentially why there'd been non-compliance with the law. And it should be noted, just one reference in relation to that is of some significance. If you, at 1966,
there's no reason to think, had Corporal Brown been designated and authorised, there's no reason to think that this material would not have been provided. There was no substantive reason why that material wouldn't be provided, is there? I'm just asking.
Well, the way in my submission to approach that, and can I, in one sense, take issue with the way the question's phrased, rather than, and I will answer it directly if I can as well in a moment, but I'd take issue with the question. In our submission, if the Crown is going to say it doesn't make a difference, it has to adduce evidence of that. Now, in a case like this, the role of the Minister and anyone who's been designated by the Minister is important, because it is essentially intended to act as a check. It's intended to ensure that the police can justify a substantial interference with privacy rights. Now, the way in which you potentially it would have been potentially open to the Crown to call, for for example, the minister or someone they designated and say, who could have said, I'm the designated person, I've looked at this, there was a good reason for making that material wasn't produced. So one simply doesn't know that. So
the investigation of a very serious criminal offence targeted at people alleged to have been involved in that very serious criminal offence would have justified disclosure of this material?
Well, you need a sufficient. I mean, you can't because of the privacy material.
Okay.
You can't.
So you don't
just
accept.
I don't accept as a matter of principle that you need enough. You need a good basis for believing that evidence may be relevant. Of course. I mean, the whole point of the legislation, it seems, we would submit, is to strike a balance. So it's to recognise that there may be circumstances in which the evidence will be of value and to enable a route by which it can be obtained, but restrict those circumstances by putting checks in place. So that's why we would submit that on the material available, one simply doesn't know whether a designated person would have. And just one.
Whether a designated person would have made the application.
Sorry, whether the designated person would have authorised it. Yes.
Well, the designated person doesn't authorise the notice to.
Yes, because that's in one sense the author. My lady was asking me the point about designated officer and authorised officer, and in one sense, the designated officer, in a very real sense, the designated officer is the more important safeguard, because he or she is the person who gives authority, and they're the one who needs to ensure that there's a sufficient justification. I assume the reason why an authorised officer is needed to receive the material is to make sure its privacy is subsequently protected.
Yes.
But the authority is given by the designated officer, and they're the person, in one sense, who is perhaps the more important safeguard.
Well, how do you square that with your submission about the importance of the material?
Well, when we look at the material now, we know that the material found was important. But that doesn't mean at the time the application was made, there was justification, because obviously when making the application, you don't know what, as far as I'm aware, there was no reason to believe that there was knowledge essentially of what that material would show. That doesn't mean it wasn't justified making the application. It may be that the officer had sufficient information to demonstrate that there was reason to believe there were telephone communications. But we now know the relevance of that material. The question that we don't know in my submission is whether a designated officer, knowing what was known at the time the request was made, would have been satisfied that the justification outweighed the interference with privacy. And that's an important safeguard. That's clearly why the requirement for a designated officer exists. It's to stop fishing expeditions. It's to ensure that there is a proper basis for making the application. So that, can I just draw attention to one other reference in the material about this, which is going back to the point I made about the need to, in one sense, have material about the system and how Corporal Brown wasn't effectively given clear directions as to what he needed to do with. If you go to 1966 of the authority, not of the authorities, of the electronic bundle, line 10, there is a submission there made by the Crown, albeit one that's made apparently without an evidential basis expressly for it, because no evidence was called in relation from a commanding officer, as far as I can see. But in support of the submission that Corporal Brown was acting in good faith, the reference was essentially that this procedure had been dictated to him. Now, that raises a question. That's why, in one sense, we submit striking that there was no evidence about the command structure, how this system had been allowed to remain in place despite the clear terms of Section 16 and despite the clear terms of Section 16 and despite the judgment of the Court of Appeal. And the Crown makes the point, or argues, essentially, that the defence didn't argue that Corporal Brown's acts were, they didn't challenge the submission that Corporal Brown's actions were in good faith. Firstly, we would submit that making whether or not the actions were in good faith sets up a false dichotomy. Essentially, there isn't in our submission a simple distinction between actions that are in bad faith and all other actions. The reality is that breaches of constitutional rights, such as those in this case, fall on a spectrum. For example, somebody can act in good faith but still be negligent by simply not paying sufficient attention to their legal obligations. They can act in good faith, but there can be a failure by those in command of them. Secondly, the submission that is highlighted by the Crown about good faith was essentially an argument that good faith was irrelevant to the breach of the legislation. It wasn't essentially a submission about how the court should approach the consequences of the breach. In terms of the consequences of the breach, the submissions, as I say, were pretty clear that there was an argument, essentially, that there'd been a breach of the Charter and that should lead to the exclusion of the evidence. And the trial judge recognised the significance of arguments about the breach of the Charter. The charge, if you go to 2237, bottom of the page, lines 23, the trial judge indicated he recognised the force of the arguments that there'd been a breach of the Charter, apparently accepting that there'd been a breach of the Charter. But at 2240, at lines 13 to 20, essentially, he cited Khan, and in particular, 2240, he cited Phipps.
No, I'm going to ask you. Listen.
The Jamaican Court of Appeal Authority, which indicates that.
I think he cites Khan on 2240.
224. Well, right at the bottom, he cites Khan. He cites Phipps before Khan. Sorry,
I
was misreading my own notes. I'd gone to 2241, and that's what was slightly confusing.
Yes, I see. 2239.
Yeah, he cites Phipps. He then cites Khan. And what he does at line 20, rather, at 2241, is he indicates that essentially that the breach of the convention does not mean the trial is unfair. And applying Phipps, if you then go over to 2242, line 17 onwards, he indicates that the issue is relevance and not how the material was obtained. So on the face of it, particularly at 2242, what he's doing, applying Phipps, which itself goes back to Khan, which we submit is the wrong approach, he directs himself that the only issue really is the relevance of the material. It doesn't matter that it was obtained in breach of the Charter. And that's, we would submit, the approach that was adopted by the Court of Appeal as well. If you go to 5833,
sorry, page?
Page 5833, 147. You see the application of King and Phipps, and then if you go on to 5836, top of the page, which is the end of paragraph 150, the judge adopted essentially the correct approach. The indication is that the judge adopted the correct approach applying King, and that led to the rejection of the arguments about the Constitution. And so the Court of Appeal proceeded on the basis that there was a constitutional issue raised, a charter issue raised, but rejected it given the application of King and given the application of Phipps. We submit that is a misdirection, and that had this been approached properly, given the evidence I've taken you to, and in particular the absence of evidence to explain essentially how it was that Corporal Brown, despite apparently being aware of his legal obligations, didn't ensure that there'd been compliance with those legal obligations, we submit that in those circumstances that the evidence would have been excluded. Now, the reason we submit it should have been excluded is this. Firstly, it's important to start with the Constitution and the Charter. And the Charter in our submission, the reason for that is that we submit, obviously, that it's important to look at what the Charter itself says to see what approach essentially should be adopted to breaches of it. And the Charter is electronic bundle 6248.
6248. Thank you.
Just before you move on to this, are you submitting that the approach in Phipps and King is that one is not concerned at all with how the evidence is obtained, that there's no discretion?
I'm submitting this, that King and Phipps, certainly the way the judge understood this, and I wouldn't disagree with this, is concerned ultimately with the impact on the fairness of the proceedings, not how the material was obtained. Now, there are circumstances possibly where how the material was obtained may have an impact on fairness. I mean, if you torture someone, that would probably have an impact on fairness. But the critical difference between that and Muhammad, which is what the approach of this court to written constitutions, is that what Muhammad does in our submission is recognise that there is a significance in a state incorporating rights within a written constitution, effectively elevating those rights as being ones that have to be given particular weight, and that even in circumstances where perhaps there isn't an issue about fairness, what the court needs to do is balance the unfairness, sorry, not balance the unfairness, balance the nature of the breach against the interests of the state in admitting the material. And so the fact of a breach has to be given weight. And Muhammad recognises that that is a different approach to King. He expressly says that.
So do you not take into account the fairness, the impact on fairness as part of that balancing exercise at all? You just weigh breach as against interests of the state in disclosing?
Well, you can't, obviously, because you have a constitutional right. Now, I'm not arguing you can have an unfair trial, but the nature of, but what you can have, in my submission, I'm not saying you wouldn't take account of that. What you can have is a situation where the nature of the breach is sufficient on its own to justify exclusion, because the nature of the breach...
Yes, no, I understand that, but I thought in answer to my Lord's question, you were saying you don't any longer, as a result of the Charter, have regard to the impact on the fairness of the trial.
Can I just slightly modify my answer? I was referring to Mohammed, and we obviously go one step further, arguably, by referring to the Irish case law. So we would potentially go a little further, and I'll come on to the Irish case law in a moment. But before I do, what I was trying to do, just to be completely clear, is draw a distinction between the King and Phipps approach, which is simply focused on the fairness of the trial, and doesn't necessarily give any weight to the significance of the breach, and the Mohammed case, which does give weight, and very real weight, to the significance of a breach because of the importance of a written constitution. If I suggested that fairness wasn't a factor, then that was lazy language on my part.
So you accept it is a factor?
Yes. It has, yes, I would accept under Mohammed it has to be a factor. Yes. Yes, but as yes, just to re-emphasise though, the critical point about the Mohammed case law is it gives weight to the inherent significance of a breach of the Constitution, and so it can lead to exclusion simply on the basis that there is a need to protect and vindicate constitutional rights, and that's the distinction we would draw. Going to the Charter, that's, as I think I indicated, 6248. I should say we've used this unofficial version. I've had this issue before. There is, as far as we've ever been able to discover, there is no official version of the Charter, of the amended Constitution, including the Charter. So you can find the legislation that includes the amendments to add the Charter. You can get a version of the Constitution that doesn't include the Charter. This is the only version that we've ever been able to discover of the fully amended Constitution, and that's why we referred to it, but it is formally from an unofficial source. There doesn't appear to be an official source which is for the Constitution fully updated. The key provisions, firstly, to draw attention to, can I draw attention to section 13(1)A and C first? They are, well, the whole of section 13(1), really. The first point I wish to make is that section 13(1)A imposes a positive duty on the state to promote observance of human rights. Now, that is, in our submission, a demanding standard, and it goes beyond a mere obligation to comply with the human rights standards contained in the Charter. And it's part of the context in which admissibility questions should be viewed. Obviously, a key way of promoting observance with human rights is to ensure that non-compliance with the Charter has consequences. 13(1)C I draw attention to because it demonstrates, and there are other features of the Charter that reflect this, the fact that Jamaica's approach to human rights goes beyond, in one sense, a European approach because it applies to all persons. The obligations under the Charter apply to all people. And that was looking at the debates, a positive decision. And it demonstrates a key feature, and I'll take you to some material that makes good this submission, of the Charter, which is a desire essentially to enhance rights reflecting the fact of Jamaica's independence. Section 13.2 then indicates that effectively the rights that follow in Section 13 have to be complied with, save as may be demonstrably justified in a free and democratic society. Subsection B makes it clear that no organ of the state shall take action which abrogates, abridges, or infringes those rights. That's important for a couple of reasons, we would submit. Firstly, it makes it clear that there is an obligation on the courts, because as an organ of the state, essentially, to ensure that those rights, the rights that are incorporated within the Charter, are not abridged. Secondly, when read then with subsection 3J Roman 3, which is about the privacy of communications, it explains why in our submission it is clear that a failure to comply with the relevant legislation, the Interception of Communications Act, is a breach of the Charter. And the reason, quite simply, is the legislature has decided effectively the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified, essentially, because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reid made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why in our submission it is right to it's right that the courts below proceeded on the basis that there was an interference with the right to privacy. Now, one thing I should just touch upon is that the prosecution say, well, it's absurd, I think is their language, to argue that the constitutional rights of Mr. Chow, or the deceased, or his girlfriend were interfered with. In our submission, firstly, the approach to waiver will become clear when I come to jury rights, and in our submission there's no suggestion of waiver. But in any event, it misses the point. The whole point about the Interception of Communications Act is that in a modern society, clearly there is a huge amount of data held by held on all of us by people like communications companies. So there is a need for safeguards, because there's no reason to believe that the material obtained was necessarily restricted to the deceased, his girlfriend, or Mr. Chow. All the indications are sort of indicated that it goes beyond that, and that's why these safeguards matter in our submission. Two other provisions worth just noting. Firstly, partly so I can avoid going back to them. Firstly, section 16 is the right to a fair trial by an independent and impartial court. Included within that, in the criminal context, at subsection 6G, is the right not to be tried in your absence. That is obviously relevant when we come to the jury issues. It does have some implications, though, for the first issue, the admissibility, because in our submission, and we've made this clear in our written statement of case, there are issues that potentially arise if the state breaches constitutional rights. There are fair trial issues, not least because, in one sense, the state then has an inequality of arms. It has used the powers it has in an unlawful way. The other provision we draw attention to, because it was touched upon by the trial judge sort of indirectly, is if you go to section 19.4, section 19 is essentially concerned with redress. And in particular, section 19.4 recognises that although the Supreme Court may, has jurisdiction generally to deal with breaches of the Charter, a point the judge made, there is a need, because redress has to be effective, for other courts potentially to exercise their jurisdiction. That links we would submit to the Brandt case, which we've referred to in our statement of case, which indicates it could be an abuse of process, essentially, to go to a court like the Supreme Court in the course of criminal proceedings. And we would say that the more fundamental point is that we can make about section 19.4 is it demonstrates the importance of redress being effective. And that, in our submission, is part of the reason why it's important that, in appropriate cases, evidence obtained in breach of the Charter is excluded. The Charter itself is, just to be clear, an unusual provision within the Caribbean, in the sense that, and this is recorded in a book that we've included in the authorities, page 8334, the Oxford Handbook of Caribbean Constitutions, is that Jamaica is one of only 3 countries that has made significant changes to its independence constitution. In Trinidad, they are described as being cosmetic. In Guyana, they were concerned with the presidency being introduced. But in Jamaica, obviously, they were focused on human rights, and that's important. Jamaica is, as far as we can see, the only Caribbean country that has used independence essentially as a way to enhance human rights. And one sees the fact it was intended to enhance human rights in the Joint Select Committee report that led to the Constitution. If you go to 8213, this is the final report. There is a lengthy history, and we've set it out in our written statement of case. I'm not going to take you to it, and we've included the materials about it. There's a lengthy history of debate. It was a particularly long debate process. But the final report of the Parliamentary Joint Select Committee, it helps in 2 ways. Firstly, it makes it clear at 8213 that the Constitution was influenced by other written constitutions, and that's partly why we submit we're entitled, for example, to refer to the Irish Constitution, because it is a written constitution with similar features. Clearly, part of the aim of this process was to reflect developments in other states. More importantly, though, in one sense, one of the recommendations of the committee, which was adopted when the legislation passed through the Jamaican Parliament, it is set out at 8211, and that is that there should be a limited preamble reflecting the historic background, essentially, to the legislation, but most importantly, making it clear that what the legislation, the Charter, was intended to do was produce, and I use these words because they're found in the preamble, was produce more comprehensive and effective protection of fundamental rights. So the clear intention of the Jamaican legislature when adopting the Charter was to enhance human rights. And that's reflected, I think, given time, I'm not going to take you to it, but we would refer you to the judgment of the Chief Justice of Jamaica in the Robinson case, first instance, but it is a judgment of the Chief Justice reviewing the significance of the adoption of the Charter, and that's particularly paragraph 203.
Page.
Sorry, it's page, yes, sorry, I should have given you the page. It's 6472, particularly, in fact, paragraph 6475N. And so there has been reference, it's not my term that I came up with, as to how the Charter is a Jamaicanized version of human rights, or it's a Jamaicanized approach to human rights. That's the context in which one should look at Muhammad. And Muhammad is in one sense, perhaps the least we ask for, or the least we argue for. In our submission, it reflects the current approach of this court to written constitutions. Now, Muhammad starts at 6301, and it was concerned with a breach. You see it at para 11, it was concerned with a breach of constitutional rights resulting from the admission of a statement. Now, my learned friend says, essentially, just to address one point, that there is a difference, because what happened was in Muhammad was a breach of an express provision in the Constitution. He suggests there's a distinction here, but in our submission, nothing in this judgment indicates that there are different types of rights protected by written constitutions. The fact of the matter is, either there was a breach of the Constitution here or there wasn't. And as the issue is identified at paragraph 11, the issue in Muhammad was the consequences. And the approach of the Court of Appeal, having rejected an argument based on US case law, essentially that there was an absolute exclusion, the approach of the Privy Council, essentially having reviewed a number of other judgments of a number of other courts considering written constitutions, is at 28 and 29 of the judgment, which is 6308. Couple of points that, well, just to highlight a few things. Firstly, and it's important given the facts of this case not to lose sight of this, at the top half of paragraph 28, the court makes it clear that if there's a dispute about facts, the burden is on the prosecution, essentially. And that it was said to expressly include, for example, whether there was deliberate infringement of the rights. And that's important in our submission. Firstly, it clearly reflects the criminal standard of proof, but it does in our submission demonstrate in a case like this that if the Crown is going to say, for example, we could have obtained this material in any event, it needs to demonstrate that by evidence, essentially, as to from the relevant designated people. It also needs to explain what happened in relation to leadership in this case. Now, in terms of the test to be applied, the court notes, and I accept it expressly says this is in the context of Trinidad and Tobago, and that's important in one sense because obviously each constitution will have its own features, and as I've already indicated, Jamaica has this unusual feature of having adopted a deliberate, rather having rejected or amended the independent constitution and replaced that with a constitution which was intended to reflect a lengthy debate that had taken place within Jamaica. But it said in the context of Trinidad and Tobago, the approach is neither prima facie exclusionary nor prima facie inclusionary, but there is a need to weight the interests of the community against the interest of the individual who's been exposed to an illegal invasion of their rights. Now, that is the context of then what follows in paragraph 29, and paragraph 29 is quite clearly a rejection of the King approach on the basis that there was a distinction to be drawn between constitutional rights and common law rights. And the reason it does that is because it indicates that it's of fundamental importance that a right is important enough to be contained within the Constitution, and constitutionality has to be given meaning. It shouldn't be meaningless. But it recognises that it's also necessary to consider the nature of the guarantee and the nature of the breach. The ultimate conclusion quite clearly is towards the bottom of the page, where the court talks about breach of a constitutional right being a cogent factor militating in favour of the exclusion of the confession. And that's the critical point in one sense, going back to the question I think my Lady Simler asked me. The difference between the approach adopted in Phipps, the difference between the approach adopted in this case and Mohammed in our submission is quite clearly the fact that there is a need to consider the circumstances of the breach, and that breach itself per se is an important factor that potentially results in exclusion. And that is simply not the approach that was adopted by the Jamaican courts. Now, what we've sought to do, though, one of the issues that potentially arises from Mohammed, and it's one of the reasons why we've gone further in one sense and looked at JC, the Irish authority, is this. One of the difficulties in practical terms we would submit for a trial judge faced with a Mohammed argument is that, as with any balancing exercise, it can be very difficult to work out what weight should be attached to a breach of the Constitution, what factors are particularly important. And that's important because the temptation will always be to admit something because it seems of importance. There's an understandable reluctance to exclude evidence that potentially is important evidence of guilt. But the risk of that in the long term is that weakens the constitutional protections. Part of the point of Mohammed is that breaches should have consequences. If they don't have consequences, then the Constitution is undermined. And JC in our submission, one of the reasons why JC is important is because JC is based on similar idea. It's based on the idea that there needs to be a balance, but it's an attempt to give, in one sense, greater clarity. And the Irish Supreme Court expressly recognised the importance of clarity, because clarity means that the consequences of breaches are foreseeable. It means that the incentive essentially to breach is less. And that incentive, I mean, minimising that incentive is important. And it links in one sense, thinking about it, to a point, again, that my Lady Simler made to me a moment ago, which is, wouldn't this material in any event, paraphrasing, wouldn't this material in any event have been admitted? If it would have been admitted in any event, the question immediately becomes, potentially, why was the shortcut taken? The police knew about Phipps. Why were they taking the shortcut if they could have obtained this material in any event? And that's one of the reasons why it's important to have clear guidance, because police officers in those situations need to understand what the consequences of their actions are. JC is in the authorities bundle it's in the bundle at 6641. And we submit it is of significance for a number of reasons. Firstly, the Irish Constitution, obviously, like the Jamaican Constitution, represents decisions by a relatively newly independent state as to what rights should be given particular protection.
Junior.
Secondly,
if you don't want the, you know, for the brother, you know, try to type the same thing over and over again. People want to hear for themselves, bro.
Page 6670.
Left it at that, no, man.
Sorry, paragraph
97.
Thank you.
Like the Jamaican Constitution, there is no express rule dealing with the exclusion of evidence. So what the court was trying to look at was what should be the implied rule, effectively. Now, what there is within the Irish Constitution, if you go to paragraph 4.18 of the judgment of Mr. Justice Clark, which is essentially the lead judgment on the approach to be adopted at 6686.
Feel upon JCPC live.
There is an express obligation on the state to vindicate the rights of the citizen
Brother,
as far as possible.
We're not saying you can't say nothing, but you entered the chat about 5 minutes ago, and at the same thing, yeah, so you already see it.
So
people
there is a
here.
positive duty
brother, like,
on the state,
these people for listen for themselves,
essentially to protect rights, a factor that was relied upon. Here, we've already made the point about the language, particularly of section 13.1 of the Charter, which in our submission does impose, perhaps unusually in a human rights context, positive obligations on the Jamaican state to promote rights. Not only that, the Constitution includes a right to adequate redress. I took you to the provision, I think it's section 19. And it sorry?
Redress for what?
For a breach of the Constitution.
Of whose? I might have imagined redress might be for the breach of the constitutional rights of the person who was seeking redress.
Well, yes. I mean, obviously that's an important...
Can anyone seek redress for a breach of anybody's constitutional rights?
Well, in our submission, anyone can enforce those rights because of the first point I made, which is about the need...
That's what you're seeking to do in these proceedings.
Sorry?
And that's what you're seeking to do in these proceedings.
Well, that's what... Yes, because we're yes, because that... Well, it goes back to the Muhammad...
Junior, you watch it already and don't know who is Mohammed. You see it?
Breach of anything. It's not the rights of Mr. Jones and Mr. St. John.
That's... Well, there clearly were issues in relation to one of the defendants, but as constitutional rights, because there was data in relation to one of them.
That's Mr. Campbell?
Yes, Mr. Campbell. But the more important point in any event is that what this case law, I mean, what Mohammed it recognises is that, and this is made even perhaps more expressly clear by the Irish Supreme Court, is that if the courts simply ignore breaches of constitutional rights, then there is then the problem is that there's no incentive essentially on the state to comply with them, or there's very little incentive on the state to comply with them.
Well, Mohammed was dealing with a breach of the defendant's constitutional rights in relation to the obtaining of a confession.
It was dealing with a breach of his rights, but it was referring to but it was referencing the importance of breaches of constitutional rights generally. It was referencing the need to uphold the standards of the Constitution, and it goes back, if you consider the Jamaican provision, and it's why I started with it in one sense. Article 13.1 makes it clear that it's a positive obligation on all parts of the state, essentially, to promote human rights, to another way of phrasing that would be to not turn a blind eye to a breach of human rights. And that's, in our submission, what Mohammed is concerned with. I mean, if you think about the facts of this case, you had, on the evidence that you've got, the police were aware of their obligations following FIPS. You had individual officers who clearly were aware of their need to comply with Section 16. On the face of it, at the very least, they didn't investigate whether they were complying with Section 16. That, on the face of it, is a breach of the Constitution, and yet, on the approach of the Court of Appeal and the trial judge, that has no consequences. What's in one sense to stop police continuing to adopt a procedure which is clearly in breach of the Constitution? And that's why, in my submission, the point that that's made by the Irish Supreme Court about there needs to be a sort of clear rules to ensure compliance with constitutional rights is important in my submission. Lord, given time, I'm going to try and speed up a little bit, but just to be clear, the approach of the Irish court is based on the features I've drawn attention to, and based on also the need for consistency in approach, which you see at 4.16 of the judgment. It's to set out, essentially, a clear set of rules that you see at paragraph 5.1 onwards of the judgment. They are said to represent, see paragraph 4.22, the need to balance the encouragement of enforcement agencies. It's at the bottom half of paragraph 4.22. The need to balance compliance with the value of the evidence, essentially. And that compliance is important in my submission because, as I say, if there's no weight given to that factor, there is nothing to stop the police continuing to effectively ignore the FIPS ruling, ignore their obligations under the legislation, and simply and breach privacy rights. Now, what the Irish court does, and I'm just going to go through it very quickly, is it sets out a clear set of tests that focus essentially on the degree of culpability. And that's, we would submit, consistent in one sense with Mohammed, because Mohammed recognises that the nature of the breach is important. What it does, though, is give greater clarity to the nature of the relevance of the nature of the breach by focusing on whether it was a deliberate breach, considering the role of senior officers at paragraph 5.9, and then also considering the potential significance of negligence or recklessness. Given time, I'm going to, because I want to spend plenty of time on the jury point, I'm not going to go into it, JC in any greater detail, but clearly, had the JC approach applied in this case, and we make further submissions in our written case as to why JC should be followed. In our submission, if the JC approach had been followed, the prosecution simply couldn't establish why there hadn't been leadership, essentially, that ensured systems were in place to avoid this. And that, at the very least, we would say is gross negligence.
If it had been followed, the prosecution could not have established what?
JC had been followed. The prosecution couldn't establish why there were systems in place, what legitimate reason there were for not having systems in place that ensured compliance with the Act, in circumstances where they'd already known that there was an issue following FIPS. And that, at the very least, we would submit is gross negligence. On the face of it, nothing appears to have been done following FIPS.
And you say that would outweigh the balance on the other side?
Yes, because otherwise this is a case.
No, I understand. I just wanted to be clear.
Absolutely.
Outweighed the public interest in.
Absolutely.
Yeah.
That having been said, can I just add one qualification to that, which is that, I mean, in one sense, that the way in which that would potentially come into play would be if the court is considering applying the proviso, and there would be, in our submission, a potential, if the court was effectively thinking of rejecting on that basis, there would potentially be a value in having a retrial on that issue because of the value of, in one sense, the correct approach, the weight to be given to the constitutional breach, might be an issue for the Jamaican courts. I'm not inviting I mean, ultimately, we submit the appeal should be allowed, but I'm just looking at, in one sense, a hypothetical example or a potential outcome, which is the court coming to the conclusion that the test was wrong, but the correct test would have made no difference. And I just would add a note of caution about this court. If it's a balancing exercise which has to give weight to non-compliance, question mark really whether this court's in the best position to assess that, given the importance of, in one sense, local assessment of the importance of the Charter. Can I then turn to the jury issues? A couple of preliminary points about the jury issues. Firstly, that it is in our submission important to consider the jury issues together. In part, although we would say that any of the individual jury issues are sufficient for us to succeed, in part because if we're right that ultimately the question that this court has to ask itself is whether the fair-minded bystander would conclude there's a lack of independence and impartiality, everything to some extent comes together because it's ultimately the final position that was reached. Was that verdict reached by a body but which, by the stage it was reaching its verdict, was independent and impartial? And that's a reason potentially for considering everything together. And they do link in one sense, because obviously one of the concern, you'll be aware that we make submissions about what's described at times as the second incident, which in one sense for our purposes is actually the first incident, which is the juror who was discharged. But of course the juror who was released from the jury, one of the reasons that is of potential relevance is that seems to put pressure on the trial judge because he can't release any more jurors. And that's where he gets into this difficult situation where he knows that there is a juror who is attempting to bribe members of the jury, but they are allowed to continue to serve. Had they not been allowed to continue to serve, then the jury would have had to be discharged because of what had happened the second time.
So there were 3 incidents. I don't think you.
All right. So, but just find a video of the actual verdict when the man had done talk, cause. Not to be disrespectful or anything, but him a talk for a long while now and I have some things to do. So we just find a video of actually the actual verdict of what was said by the actual judge themselves. So I could jump on a video and see the exact them say. Save me a bit of time, save me a bit of time, save me too. 1 second. 1 second, let me get this over here. And you can see that, right? Not see that? No, not see it yet. All right.
Judgment in the matter of Sean Campbell.
All right, so it's a bit.
Deidre Palmer, Kahira Jones, and Andre St. John against the King.
On the 13th of March 2014,
all right, here we go, guys.
A 64-day jury trial in the Home Circuit Court in Kingston, Jamaica. The appellants, Sean Campbell, Adidja Palmer, Kahira Jones, and Andre St. John, were convicted of the murder of Clive Lizard Williams, to whom I shall refer as the deceased. At trial, the prosecution case was that the deceased and another man, Lema Chow, had been given 2 unlicensed firearms belonging to Palmer for safekeeping. On the 16th of August 2011, Campbell summoned Chow and the deceased to Palmer's house after they had failed to comply with Palmer's deadline for returning the weapons. The prosecution alleged that they were met on arrival by Palmer, Jones, and St. John, and that Chow and the deceased were both attacked, after which Chow saw the deceased lying motionless on the ground with Jones bending over him. Chow escaped, but the deceased was never seen again. Police attended Palmer's house on the 22nd of August 2011. They noticed the house smelled of disinfectant. On the 25th of August, they cordoned off the perimeter wall, treating the premises as a crime scene. When they returned on the 27th of August, they found that the entire interior of the house had been destroyed by fire. On the 29th of August, police forensics reported a foul odour emanating from the living room. On a further visit on the 30th of September, it was discovered that the rear of the house had been demolished. Police dug at the premises but did not find a body. The police seized the mobile phones of Palmer and St. John. Text messages, voice notes, and a video from those phones were put in evidence at trial. The prosecution also relied on telecommunications data which the police had obtained from Digicel, a communications provider. The prosecution case was that the mobile phone evidence and telecommunications data, taken as a whole with Chow's evidence, proved the fact of the killing, the reason for the killing, the method of disposal of the deceased's body, and the identity of at least one of the killers, namely Palmer. The 4 appellants each denied murdering the deceased. At trial, the appellants objected to the telecommunications data being admitted as evidence. They argued that the data was inadmissible because it had been obtained in breach of the Interception of Communications Act and the fundamental right to the protection of privacy of communications guaranteed by the Charter of Fundamental Rights and Freedoms contained in the Jamaican Constitution. The judge admitted the evidence. He ruled that the data could be relied upon by the prosecution even if it had been obtained in breach of the Charter or the Interception of Communications Act. Over the course of a 64-day trial, there occurred a series of incidents involving the jury. The jury was reduced to 11 members after a juror was discharged almost 8 weeks into the trial. On the final day of the trial, it was brought to the judge's attention that a member of the jury, who will be referred to as Juror X, had attempted to bribe other members of the jury. The judge questioned the jury forewoman, who stated that Juror X had offered bribes to each of the other jurors to acquit the appellants. The judge asked counsel for the prosecution and the defence if the trial could continue. It would not have been possible only to discharge Juror X, because under the Jury Act, a trial for murder cannot continue with fewer than 11 jurors. The judge decided to proceed with his summing up and gave a direction to the jury, reminding them of their function.
One more quick pause.
The jury retired to consider its verdict at 3:42 p.m. The jury returned at 6:08 p.m. and by a majority of 10 to 1 convicted all 4 appellants of the deceased's murder. A 5th defendant was unanimously acquitted. Juror X was immediately arrested and was later convicted of attempting to pervert the course of justice. There was no evidence to connect his activities with the appellants. The appellants appealed against their conviction to the Court of Appeal of Jamaica, which dismissed their appeals. The Court of Appeal granted permission to appeal to the Judicial Committee of the Privy Council on 3 grounds, which were, first, that the trial judge failed properly to inquire into allegations of juror misconduct. Secondly, that the trial judge departed from standard practice in inviting the jury to retire to consider their verdict so late in the day, putting undue pressure on them to reach a verdict. And thirdly, that the trial judge erred in admitting the telecommunications data because it had been obtained in breach of the Interception of Communications Act and the Charter. The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct, and that the case should be remitted to the Court of Appeal of Jamaica to decide whether to order a retrial of the appellants for the murder of Clive Williams. The Board has considerable sympathy with the dilemma faced by the trial judge on the final day of a long and complex trial. Following the allegations of bribery, he had either to continue with the 11 remaining jurors or to discharge the jury. Despite this, the Board considers that the approach taken by the judge was a material irregularity in the course of the trial, which makes it necessary to quash the convictions. This is for 3 reasons. First, the direction to the jury on the final day was inadequate to save the situation. The judge simply reminded the jury that they had sworn or affirmed that they would return verdicts in accordance with the evidence they had heard in court. The judge did not refer to the alleged bribery, of which, if the allegations were true, the jurors were already aware. Secondly, the trial continued with the allegedly corrupt juror serving as one of its 11 members. In the Board's view, there should have been no question of allowing juror X to continue to serve on the jury. Allowing juror X to remain on the jury is fatal to the safety of the convictions which followed. It was an infringement of the appellant's fundamental right.
That's not me, guys.
Under the Jamaican Constitution. Thirdly, the judge should have considered whether the remaining jurors might have become, consciously or unconsciously, prejudiced for or against one or more of the appellants as a result of juror X's behaviour. For example, there was a danger that the attempted bribe could have made the other jurors overcompensate, consciously or unconsciously, if they assumed that the offer must have come from one of the appellants and that therefore they must be guilty. The judge took no account of this risk. The Board is very mindful of the serious consequences which may flow from having to discharge a jury shortly before the end of a long and complex criminal trial. It is also very conscious of the danger of deliberate attempts to derail criminal trials by engineering situations in which it is necessary to discharge the jury. In England and Wales, there is legislation which allows a judge in certain situations to discharge a jury because of jury tampering and to continue the trial by judge alone. There is no such legislation in Jamaica. It follows that there will be occasions where, as in this case, a court will have no alternative but to discharge a jury and end the trial in order to protect the integrity of the system of trial by jury. In view of its conclusion on the issue of juror misconduct, the Board holds that it is not necessary to express a concluded view on the other 2 grounds of appeal. For these reasons, the appellant's appeals should be allowed. The Court is now adjourned.
All right, there no have it. Basically, they must say it should be it should be quashed. And now it's up to the Jamaican court if they want to do a retrial. What you guys think about a retrial? One can join. I've only got like 10-15 minutes. One can join. Say what I say and make me hear one think by clicking that link and forwarding. You see me? Shit. Teacher. Why? I don't know. If the court of Jamaica I gonna say your retrial and actually do it, because if them say it, it gonna cost taxpayer a lot of money. If them say retrial, it gonna cost taxpayer so much money, like, because if you remember, cartel case is the longest case in a Jamaican history so far. So I don't know, but it's a big step forward. The cartel them, but it's not over yet. It's a big step forward for him, but it's not over yet. Him and Sean Storm and the other two G them, but it's not over yet. So make we see where Paula Llewellyn and the team are gonna do. But like me say, if them go retrial, it gonna cost the state a lot of money. But the Privy Council basically say, "Oh, it's a quash. It's a quash," on the basis of the judge never dismiss the jury at the time. Is it after the corruption go on? So, what you guys think? Join the live and let me know one thing quickly if you don't want to join. If you don't want to join, me go end the stream and I want just call it a day because I have some things to the see me. You see me? But yeah, Cartel have a chance again to forward out. So Marlon Maji, what go on? Yeah, hear me, bro? Yeah, cut me hear Marlon. Marlon, me not hear. You have to go leave and join back with your mic being allowed to speak. I look like a data gun, bro. That's the link if you don't want to join. Yeah. We want to see Cartel Road still. Big man thing. We want to see the teacher road. Of course, we want to see the teacher road. Yo, my G, what go on, Kevin? Kevin, you not hear me? Oh, I not hear the man them. What go on there, sir? Yeah, I should be hearing you guys, man. Audio input at work, audio output. Yeah, that should be. Paula not let him out. No, she was asking for a retrial during to the appeal. It's not down to Paula to let him out though. It's down to the jury at the end. It's down to the new jury at the end of the day, bro. The lawyer did not want a retrial. I can see why. But me have two persons here. I'm not hear them none at all. Me not hear none of them. Me know if something from my end I go on or what. Me no know. But what wanna think? Shane, what go on? You hear me? Yeah, nobody can hear me.
Hello.
Twin, what go on now?
Yeah, but there, big man. Yeah, I deal with.
Up, bro. Up. You have to mute the live, bro.
Yeah, man. I always been watching you, man. I'm a fan, man. I appreciate your show.
Respect, me, bro. Respect, man.
Yo, I was just telling you about the teacher, man. Now I gotta look, I don't think it looked too good for him. I'm in good spirits, but it's like, yo, Jamaican, how just Jamaican shit stays still, you know what I mean?
What you mean, though? It not look good. What you mean?
I'm saying it just, it's kind of brim with them because they already convict them, and then it's gonna cost too much taxpayers' money.
Yeah, of course. Like, yeah.
It's just bad, man. The news, I have a little, airy feeling about it. You know what I'm saying?
Yeah.
It's just like, damn, bro. Like, yeah, Jamaica's biased. You know how it is, man.
But remember, say quash means say it done, bro. Quash means say it done. So it's up to the Jamaican court now if error, you see me?
Yeah, big man. Yeah. Right.
So let's see how it goes, bro.
Man. I would, up in England or whatever, British over, they stuff got. It's just, I have more faith in they more cooler. You know what I mean? With Jamaica, man, it's just like, damn, man. You know what I mean? It's just
you never know. You never know what go on for real. You never know.
And then you saying that the taxpayer dollars already is the longest case in history. So it's like,
it go cost.
Nah, you
Then
don't
look
want to take our next chance with, you know what I'm saying?
So, but then again, them can say, you know what, me can't bother with no retrial. On go on the road.
You see what I'm saying? Yeah. Well, that's the next
You
thing.
see me?
That's
So,
true. That's
so
true. That's true.
that would be the best outcome for them. Say, yo, listen, this was stressing. Me can't deal with this. When I go on the road.
Right.
Bro,
Right.
I don't know.
Damn, man. We just have to hope and pray still, you know what I mean? Damn.
Yeah.
Yeah, you know, when he touch road, it's going the whole place I get shake up. The whole world I get shake up, man.
Yeah. So we just hope that the G didn't touch road. But there is one of them that was on the case. I think I can't remember his name. Right. He was on a gun charge separately from this case anyway. So even if the G them get free up, him still have to go finish film time. Yeah.
Wow, damn, man.
You see me? Him still have to go finish film time, see me, if them free up, see me. So
damn, man. It look like them get where the duck get, man.
Exactly, you know? Dog.
Damn, man. They just have to pray still, you know what I mean? Damn, it's a crazy thing I'm going on, man.
Yo, make say what going on. Oh, where you call from, though? Where you call from, bro?
Nah, man, from Mount Vernon still. You know what I mean?
Oh, yeah, okay. Yeah, man, respect, man.
I always hear that. I always watch your show, man. You always, you know,
respect.
You know, good with information and, you know, all the hot topics and things, you know what I mean?
Yeah. Only when time war go on, normally come live, but normally reaction will do still, see me? Normally reaction.
With the Stefan Dan and Jada thing. I see you. That shit was mad, yo.
Yeah.
That shit was, I had me laughing.
I just that, you see me? Sanjay, you hear me?
Yeah.
You hear me, Sanjay?
Yeah. Oh, somebody else joined the line.
Let me hear myself. What you say, Sanjay?
Oh, me I said a long time never free word boss, man.
Long time never free, but in not free yet, bro. So what do you think about the whole decision anyway?
Yeah. So they said they don't find enough evidence as yet out here.
No. What them I say, it's a quash. So that means say yo, it's done this so. But them give the Jamaican court system a next option to say if them want to go retrial.
Right.
You see me? So
it's a squash it. Yeah, they squash it.
Yeah.
But still, damn, man, you know how Jamaica is. Yeah, man.
I don't think they probably will do it again too. Yeah, he said
they'll probably let them, you know, go out. Yeah. Hopefully, stuff. We just have to pray still. You know what I mean? Yeah, just hopefully, though.
Yeah.
Let's
see what go on, It's a good step. It's a good step because them could have say, yo, make it stand and just keep it right there. But at least them open up their eyes and say, yo, Shaggy go on. So hopefully that work enough for them favor and them follow the road.
Right.
Yeah,
but still, man. Yeah, man. Shit, man. I ain't gonna hold you, man. I'm gonna link you, brother.
All right, my bro. Respect, you know.
Good time. All right, peace.
All right, my bro. All right. Danville.
I pray.
Up top. Where you go, bro?
Yeah, man, I'm there. So here more answer still.
Yeah, my fam.
If them quash the case, right?
Mm-hmm.
Why them couldn't just straight out and say, yeah, what? Them do how much years them do already? 12 or 13?
But that something like that. Because him
I say yo
Holland pan in 2011, September 2011 though.
Yeah.
But 13.
I say yo, them serve enough time already. You know, the misconduct and whatever. Freedom on them.
All right.
Right? So I feel like say them, go ahead.
You see the Privy Council is not a normal court where them you say yo you're guilty or you're not guilty. You know, basically the only thing with them responsible for have to make sure say the trial goes smooth and everything was right and everything was done by the book. You
okay.
So even though them say quash, them still give them the option of doing a retrial then if them want to
do the Jamaican justice system.
Yeah. If them want to do it right this time, them have the option to say yo, you see me?
So, okay, so them still like give them a certain power in a sense then.
Yeah, so basically, all right. Say God bless you, the conviction was crushed, was quashed, not the case itself. You see me? Yes. So the case still stand.
Okay, yeah, that makes sense. That makes sense.
Yeah. So at that,
so it says either them are gonna let him go or them are go go back and retrial.
Retrial, yeah.
Boy, I mean I know that one. I like how that one is sound still. I like how that one is so brother. Because yo, even though Cartel have only people loving the streets in the world, like enough people.
Like
enough people want to see the man lock up, brother. I tell you, because them blame him for a lot of the stuff that go on in the country. In that period of time, when Cartel get locked up.
But what you know, but even though him lock up for 13 years, madness still a go on.
Well, that's true.
You see me? But
that's true.
Yeah, but a true way I say also they do blame him for a lot of the stuff. But
yeah, man, another time the man that's why them make sure say, yo, you have to go away. No, they kill the body say you have to go away.
Yeah,
man. That's why them put with Cartel, man. But the retrial thing, they don't like it still. They don't like it at all. It's another chance, you know, for him come out, but they still not like the retrial thing, brother. Swear to you.
Yeah, because if them do him in the first place,
exactly.
And no, I don't know, because obviously the house where the incident allegedly happened is now not there anymore, basically, right?
Yeah, mash up.
Yeah, so I don't know.
And them still don't find nobody. You know, there's still nobody, so I don't know. I mean, it can go back a retrial because them go under a whole heap more microscope, you know. Them have a whole heap of eyes on them, you know, where them can do certain things with them do in the first trial. You understand? So them have to go tread lightly with that. All of the stuff them when them are trying with them can't go do them thing there again. Yeah, but like we say, Jamaica, this you never know.
You never know, dog. You never know. I know that you see me, but it's a good thing that the G having money can get them to this step in the thing anyway, because obviously I know a man like me or you a case couldn't reach a Privy Council, bro.
You're mad, man. You're mad.
We're dead na that. We're dead na that.
And the liar we after is a good liar.
Yeah.
You can tell say man, can you some liar get some liar sometimes they have this big name and they not really do what them supposed to do for you, brother.
Yeah.
You can see say I sat Buchanan dog him like must see how me go fight for the youth,
yeah. Yeah. And can't tell a PM too, so obviously he might get him money. So obviously he work hard for money, so you don't know that guy already.
Yeah, but
boy, I know ya, man. I know ya.
But I was the dog free up still, but I say yeah, man. A win is a win. You have to take it how you get it.
Yeah, dog. Like me say, it could have been worse. It could have worse.
Exactly.
It could have worse. But yeah, dog.
But bless yourself, my Jim. I just want to call you and give my 2 cents still. You know, I know the thing already.
All right, my fam. Big up here. Guys, if you don't want to join, you can join quickly before me end the live, because I've been going for quite a while now and there's some stuff we got to do nearly 2 hours. So if you don't want to join in, you can join in and say what you think about the verdict when was handed down. If not, I go close out the stream. Also, look out for the throwback reaction that I've been doing. Movado, Vybz Kartel, Alkaline, all of them. I've been doing some throwback reaction, some song will drop before me start the reaction. So you can subscribe to the channel and check out the content them on the channel. You see me? Normally I don't go live until a clash of guan when we want to talk about or something like this. Normally the mix up thing and them thing them no. If it's not to do with music, I'm not into it. Me. But yeah. Junior, you hear me? Junior, you hear me? No, you're Junior. No, you have to go leave and join back and allow your mic for actually talk. Another thing, bro. You see me? I'm not here, bro. But yeah, Gaza fans them. Wanna think about the verdict and the case. Wanna think about the Privy Council verdict. You hear me? At least he got a chance. Praying for probation. All right. So if them say retrial, what can go on now? them can release them on bail if them say retrial, or them can also keep them inside until the retrial start. You see me? So there's so much curves and steps, and there's so much things to this, dog. Bail on the plate? No, it's up to the Jamaican court system to say, yo, all right then, retrial, but yeah, what? I'm gonna let you know what on bail until the retrial I go start. And have to forward back. You see me? But who knows? Who knows what am I gonna do? So basically the decision now down to Paula and Fair team and the state for say what going. You see me? Yeah. Yeah, big up Junior, man. Big up yourself, dog. But yeah, me go end the stream so unless anybody have anything else to say. Me go end the stream so. So please drop us up on the channel if you not drop us up yet. Appreciate the likes as well. Thank you guys. And I'll catch you guys probably one time on next hot topic I go on. You see me? Yeah, big up on the side, man. Some things we gotta do, you know. Peace!